Okay, welcome everybody to the Micklin Law Group's monthly webinar series. This month we will be discussing navigating through a high conflict divorce. Before I jump into the materials, can anybody who's listening just type me a note on your panel to the right so that I can know that you both can hear and that you're looking at the first slide on your screen? On your right side, you'll see you should see like a chat panel and a question. Okay, looks like everybody's able to see and hear. If for some reason that changes during the presentation, try to send me a note, although I can't guarantee that I will get to see it. All right, so welcome everybody. Like I said, tonight's webinar is navigating through a high conflict divorce case. We're going to just jump right into it. I do expect other people to be signing in, but I don't want to make those that are here on time wait any longer than we need to. Let me give you a little background of what today's webinar is going to be like, what you can expect if this is your first time with us. It is scheduled to be 45 minutes in length. Sometimes it's a little longer, sometimes it's a little shorter because I never really know how long it will take. There's always a lot of material that I want to try to cover, but I do my best to stay within the 45-minute time frame for you. I will take as much time as necessary afterwards to answer questions. Where most of you were typing in that you can hear me is also where you should be typing questions. I usually recommend you type questions throughout, even though I won't be addressing them until the end. That way you don't forget or miss them as we go into other topics. This is a one-way communication, so you can hear me, I can't hear you. But I am recording in case there's something that you missed that you didn't get to ask to repeat. And again, I said I'll be staying as long as necessary to answer any questions that you have afterwards. A little background on me to those who haven't met me before. My name is Brad Micklin. I'm the managing member of the Micklin Law Group. I am licensed to practice in both New Jersey and Pennsylvania state bars associations, as well as in the state and federal courts. I've been practicing now a little shy of 20 years. I started as a judicial law clerk, working for a judge in Bergen County fresh out of law school. I then did a couple of years of complex commercial litigation with Kessler & Associates before opening my office in 1999. Now I concentrate in high conflict and high net worth divorce, family law, and estate planning and litigation cases. The Micklin Law Group itself is concentrated in divorce, family law, and estate planning for those who are unfamiliar with my firm. Now, these are somewhat outdated, but just to give a little background, I put these into my webinars not so that you can hear how great I think I am, but I often say to clients that you don't know if you've had a bad lawyer until afterwards. So you want to do your research. I have received a couple top attorney awards in New Jersey, one published in the Legal Network, which you see here, other top 100 lawyers in the National Associates of Advocates. I've received the Client Distinction Award from Martindale-Hubbell 3 years in a row, and including 2015, which is not up here, and the Excellent Rated Attorney from Avvo.com, which is an independent rating website. I received that, I think it was 5 years in a row, 2015 not being presented up here. So other awards and accolades I've been honored to receive. I go through that more if we are meeting one-on-one, but I'm not going to make you sit through that before we get into our webinar tonight. So without any more delay, let's jump right into it and first look at the different types of divorce cases so that you can identify whether or not you have a high conflict divorce case. Now, just an opening comment. Many people think they have a high conflict divorce case when they actually don't. Many divorce cases have a lot of animosity and difficulty and conflict. Doesn't necessarily rise to the level of a high conflict divorce case in what I'm going to be referring to. Just like information I'll cover later about borderline personalities and narcissism, just because some people have these characteristics does not necessarily mean that they fit into the criteria and that you would handle it the same way as you might others. So just because you have a lot of conflict and confrontation, don't necessarily think that the information that I'm giving you is going to apply to all of your situations. So let's look at the main three types of divorce cases, at least how I characterize divorce cases. We have a business-like divorce case, we have a friendly divorce case, and then of course we have the high conflict divorce case, which we'll be spending most of our time talking about. Turning to the first one, business-like divorce case is almost like it sounds. And most often they do not have children, or they have maybe grown children. And they look at this as a business transaction. They either realize that their passion for one another is lost, maybe it really was never there in the first place. They know they're not going to have much contact in the future, especially if there are not children, and they're just seeking to divide what they have and move on. I generally say most divorce cases really only have five issues: assets, debts, alimony, child support, and legal fees. So getting through that and boiling down those five issues can bring almost any divorce case to be a business-like divorce. It's just up to the parties really to see it in that way. Next, we have a friendly divorce. It's probably slightly similar to a business-like divorce, but I would categorize this type of divorce where they have maybe a better relationship ongoing. The parties may have more of a relationship afterwards, as possibly as friends. If there are children involved, they will co-parent much more easily. As they move on to other people and other partners in their lives, sometimes they integrate families and still attend social events together. It's sort of what we hope most cases will be like, but they are in actuality few and far between. Excuse me. And then last but not least is the high conflict divorce that we're here to talk about. And this I describe almost as a war. It is a battle in almost every step of the way. It will often destroy not only the relationship between the two parties, the husband and wife, it will often hurt the relationships of their children and even their friends and family, who will sometimes get dragged into this kind of a divorce and this type of litigation. Some people, after it's over, do move on, but in my experience, if you have a true high conflict divorce, the conflict does not usually end after it unless there's no reason to continue a relationship afterwards. Like you do not have children, or your children are of sufficient age where you don't have much contact with one another. So keep that in mind as we go through, because I will be giving you tips about what to look for and how to identify a high conflict divorce. But in some cases, you want to eliminate or avoid the battle. And knowing when and how to do that will help you minimize the damage that these types of divorces can cause. So let's look at some of the factors that go into creating what would be considered a high conflict divorce case. One, you have the personality of the parties. I hear borderline personality, narcissism, which I will talk about a little bit in here. I've done other webinars that are on my YouTube page that you may want to watch to get a little more specific information. But obviously the personalities of the parties involved, and of both parties involved, will be the main determining factor of the level of conflict in your divorce case. Then there's motives. One, if the person is narcissistic, that we'll get into what drives that, but it will have a significant effect. There may have been one party that's hurt. There may have been adultery or allegations of adultery. There may be missing money, abuse. So that can cause a lot of anger and hurt feelings on one side, which can cause an increase in conflict of a divorce. And then you have the means, which drive almost anybody into a high conflict: money, power, tenacity, irrationality. Every case is going to be different. So the factors that contribute to a case being a high conflict or to not being a high conflict will vary, but these are certain types of factors that you want to look out for. All right, so let's dive a little more deeply into these factors. Let's look first at personality issues. The biggest that I've come across, so I've mentioned this on a lot of my webinars, is borderline personality disorders. It's people who are characterized with having past instability with relationships. Their I don't want to say psychosis, because that's too heavy-handed, but their mental issues, their mental focus is usually on their self-image and preserving their own image, and not really being able to see their own issues and their own limitations. They're often very impulsive and predictable. There are many types. Again, I'm not going to go that deeply into them. I do have another webinar where I do. It's called Divorcing a Narcissist. You might want to look into my YouTube page or email to me for it later so you can get a copy. But I have found not that high conflict divorces often have these types of personality disorders, but people who have the personality disorders will likely have a high conflict divorce case. So let's take a look at the most common that I come across, and that's a narcissist or narcissism. And don't confuse the term that I'm using with a person who is very narcissistic. When I speak of narcissism, I'm speaking of a person who truly has the personality disorder, the grandiose pattern of behavior, the egotistical or arrogant nature about oneself. The true narcissist is a person whose self-image is everything, and they will do everything to preserve it, unaware that this is what's driving them. It's not on their conscious level, but their need to preserve who they think they are and their need to have others continue to see them as they think they are will drive them to outlandish conduct and to cause high conflict in a case that would otherwise not have it. There's another version, a little slight deviation in histrionic personality disorder. This type of disorder is usually characterized by excessive emotions, both high and lows. It's sort of the pattern of like using excessive guilt or a manic swing in behavior to sort of control one's behavior. It's a little less common, and sometimes it's even hard to identify because the emotional swings only occur at certain points in times, and you can't always bring them out on cue like you might be able to for a narcissist. Then we have the last one I'm going to cover is antisocial personality disorder. This is, in my view, a more sort of egregious form of the histrionic personality disorder. This person views and holds themselves out almost as a victim. They're generally feel victimized by most of the people and circumstances in their lives. You'll see that they have not only been victimized in their marriage, but you'll find that past employers, they feel victimized them, maybe a parent or parents, family members. It's the pattern of behavior that characterizes how they see relationships, and it's one that drives them into creating a great deal of conflict in a divorce case. Now, some of the similarities that you'll see in all of these, one is that they're always very adversarial, and probably the most important that I stress a lot in my other webinars is their ability to, I was going to say false statements, which is what I wrote here, but it's hard to call them false. They're not false necessarily in their view. Their view of the world is usually inaccurate. But depending on the degree of severity of the BPD, the borderline personality disorder, will depend on the severity of the false statements. Generally, they are so egregious in a high conflict and so delusional that they're ironically believed, because the common thought by the court is, or by a judge, is that they wouldn't be saying or doing these things if it wasn't true, because people don't make up such incredible, unbelievable statements where, ironically, that's exactly what the case is in situations like this, which is what we'll talk about a little later, that some of the problems that are created by this is the view or the lack of appreciation for these types of issues. So let's see a little more on specific factors of how these play out in cases. First, obviously, we want to talk about custody, probably one of the most important issues that we will talk about in a divorce case, especially in a high conflict divorce case. And this is usually the issues that will keep the conflict going. I've seen sometimes for years after a divorce case is over. So let's first look at the types of custody. So you have a little background on the issue itself. There's physical custody, legal custody, and sole custody. Now, there are many other finer distinctions you'll come across in custody issues, custody cases, that I'm not going to go into in this webinar. You don't need it here, but I often tell people also stay away from the distinctions and the terms when you're dealing with custody, and just talk about what the relationship is, what the agreement is, or what you want to have. So don't get hung up on, is it joint custody or is it sole custody? Get hung up on what your rights and responsibilities are. Now, with sole custody, there's a presumption against sole custody. The case law and judges will generally say that they believe it to be in the child's best interest to always have both parents involved, almost despite any regard for how those parents interact with one another. My personal belief is that is completely incorrect and inaccurate when you have a high conflict divorce, which is precisely why you have a sole custody designation in New Jersey. But it's a very difficult presumption. It is rebuttable if you can show it's in the best interest of your children. It's very difficult to rebut it. I'm going to show you in a second some of the ways that you can, some of the issues that a court will look at if you are trying to rebut this presumption, if you are interested in seeking sole custody. Severe mental disability of one of the parents, incapacitation or inability to parent, incarceration or hospitalization also leading to an inability to parent, drug abuse, history of physical abuse, child neglect. These are some, obviously not all of the issues that will allow or facilitate a claim for sole custody. Even when these cases are, or these issues are present, it is still very challenging to obtain this type of custody. So it's really something that you need to prepare and really work for. Again, I do have, I believe, a separate webinar that I did on these types of issues. If you're interested in getting a little more specific on a custody issue, especially if you have a high conflict divorce, you might want to get as much background on this issue as you possibly can. So let's just take a second to see why there is a presumption for joint custody. And that's, like I was saying before, they think it's in children's best interest because it presumes both parents are fit. And the presumption is that you wouldn't necessarily have had children together and parented together for what is usually many years if there wasn't general basic fitness to parent. So again, this is not necessarily the case in a high conflict divorce, but these are the issues that you have to remember that you're confronting. So you need to be prepared to rebut them. And I don't mean by a legal standard. I mean, you need to be prepared that this is what you're going to face. And this is what you're going to have to convince somebody does not exist in your case if you have a high conflict custody or divorce case. Now, if you already have custody, the issue becomes, well, how do you change it if there's high conflict or even if high conflict develops later? Now, the general standard to modify custody is a substantial change in circumstances that affects the health, safety, or welfare of the child. That's generally more simply called the best interest standard. Courts will generally decide most custody issues based on what they believe to be what's in the children's or child's best interest. In making this determination, if you do show a substantial change in circumstance warranting the review in and of itself, you're going to have somewhere between 11 and 13 factors that the court will look at to determine it. I say 11 to 13 because they kind of group in the statute issues that I think should be separate into one sentence. So ability to communicate, which is generally non-existent in a high conflict divorce. Willingness to accept custody and history of unwillingness to allow parenting time, very important. We'll get into a little later about the need to document these types of issues. The relationship of the child with the parents, that, depending on the age of your child, is or is not relevant. The older the child gets, the more important this one is, and also the history of domestic violence, which is lumped into this one. The safety of the child and safety of the parent from physical abuse by the other parent, very important. But one issue when it comes to abuse that people need to be aware of, that unfortunately there aren't often witnesses to abuse and abusive relationships. So documenting it and substantiating it later can be a challenge. So you need to know going in, if you have an abusive relationship, you need to identify that you do have one, and you need to start preparing going forward that that's going to become an issue you need to be able to establish. The next issue is preference of the child. And it says when of sufficient age. In my experience, it's usually around 13 that they will start listening to a child. Mind you, I've never seen any case where they let the child make a decision. It's sort of like letting a child decide whether or not to go to the dentist or to school. But around 13, they will start looking to the child's preferences to factor into the decision. And the needs of the child, obviously important, educational, medical, social needs, to name a few. Going into a few more, stability of the home environment, continuity of education, meaning if the parents after this divorce or after your custody case will be living in different towns or different school districts, how is that going to affect the continuity of education and the home environment for the child? Fitness of the parents, again, you walk in, like I said before, with the presumption that you are fit, but circumstances change, and if you're able to show either the BPD issues or abuse issues, then fitness will become an issue that they will inspect. Proximity of parents' home, meaning once you separate, how far or close are you to one another and to the child's schools, doctors, extracurricular activities, friends, things like that. The extent of and quality of time spent, and this is important when not only just for custody, but if you're looking for sole custody, because the nature of a parenting relationship is no longer determined just by the number of days and overnights that a parent has, but the activities that that parent engages in during their own parenting time as well as the parenting time of the other person. So if you have, for instance, a parent that has an alternating weekend schedule and only has 2 overnights every 2 weeks, but picks the child up every day at school and brings the child to school and does laundry and wash, you may have a joint parenting relationship even though you have a great disparate amount of parenting time between them. And then lastly, the age and number of children. Not only natural families, but you also need to look at stepchildren, step-siblings, step-families, which are becoming more and more common now. How does that affect changing custody of your child if there's stepchildren that are involved in the picture? Even if they come into the picture later, it could be a change of circumstance, like we talked about before, to change a custody arrangement. These are obviously the factors for any custody case. They are more important and inspected with much greater detail in high conflict cases. So another issue that's very important to understand and be aware of, ready for in high conflict divorce cases, are contempt motions. They are often the most common way to move or get movement in a divorce case or in a high conflict divorce or custody case. Before I go into the specifics of them, there's one point I do want to make about contempt motions that in a high conflict divorce case can often make the less battlesome party suffer more. In my experience, courts are not as willing as you would expect to strenuously enforce their orders or to rigorously punish people for contempt. So if you have a narcissist who is dead set on non-compliance with court orders, you may be filing motion after motion to get compliance and getting very little relief from the court. And something that you need to know in advance so that you know exactly when to file them and when not to, but also that you're ready to take the burden that's going to fall onto you for needing to do them in the first place. It's one of the most unfortunate aspects of our divorce and family law system, in my experience, especially in a high conflict case. So let's look at what they are, what they do. Contempt motion is for failure to abide by a court order. It's called a motion for litigants' rights. You're basically saying that you have a court order and that person did not do what the court had ordered, so your rights were violated. They will result in the issuance or a holding of a contempt proceeding. The motions for litigants' rights are generally granted, or at least in part, as long as you carefully file them and you clearly have your rights delineated in a court order. Sometimes you will get, as I was walking into now, contempt proceedings before the decision actually made. The hearing can, one, be used to determine whether or not the person has in fact failed to comply or the reasons for it. The contempt proceedings may also be to determine their ability to comply, like for payments, there may be an ability to hearing for contempt of non-payment of support. There are a vast array of sanctions that the court can issue. They can issue arrests, they can issue financial sanctions, they can do additional court orders for other relief. Things to keep in mind when you're filing contempt motions is not just to ask for findings of contempt or punishment for the past behavior, but ask to have provisions included to prevent future non-contempt or to make up for what you lost because of it, like additional parenting time. If you had a denial, you may want to put in that in the event that the contempt occurs, there are future sanctions or daily fines, for instance, or if you miss parenting time, that you automatically get a make-up parenting time. You want to put some teeth into the order in the future. In high conflict divorce cases and in custody cases are kind of one and the same. Non-compliance is a chronic problem that I don't know how to describe this, the weaker spouse, the non-adversarial spouse will encounter most often, and probably one of the biggest burdens. Speaking of burdens, costs, another very important issue to look at when you're entering into or discovering that you have a high conflict divorce case. It is one of the biggest things that you need to consider and plan for right out of the bat, because it is a form of control, and more often than not, a high conflict individual, especially like a narcissistic individual, is often somewhat successful in their professional realm, and therefore they have greater financial freedom. They often are also the ones who are in control of the family finances, so they have more access, even if it's not significant assets that the family has. They have greater control over it. They have the ability to use it and to restrict use of it. So cost something you really got to dive into early on, as soon as you identify that you have or will have a high conflict case. In my experience, a divorce with high conflict can be a minimum of $10,000 to $25,000 for legal fees, and this is per spouse. It's usually not, most divorces are not based on the complexity of the issues. The costs are not based on the complexity of the issues, but the complexity of the people. So you have a high conflict divorce case with no assets or debts and grown children, you still may have the significant costs. You know, it's upsetting to me, because I often say to people, I'd rather them put this money into a college fund for their children, and they just can't see it. Sometimes it's the people with the least who fight the most. And again, if you have a BPD issue, you may not have any control over what that person is doing or the type of litigation they're waging, and even the costs of it. And legal fees are not the only cost to have to consider. In many of these cases, you will have expert witnesses. They will cost anywhere from $2,000 to $5,000 to retain to get a report. And this is only just for the report. Experts, if you have a trial that's coming up or that you are likely to go to trial, you probably add another $5,000 onto this. Depends on the type of experts. Generally speaking, in divorce, you will have three types of experts. You'll have a forensic, a business evaluation, and financial experts or advisors. Forensic, usually to look at lifestyle analysis, cash accounts, money in and out. Forensic is sort of like an investigation to see if there's missing money or how the money was used, what money is necessary to continue the lifestyle that you have. Business evaluation, just as it seems. In here I wrote small business, but really it's for any business. If you have a business, you're going to need to have evaluated in a divorce case. And then there's financial experts and advisors. A little more important in a high conflict divorce and a high net worth divorce, either one. It's great to have business evaluation and forensic, but without some real advice about what you're going to need and how you're going to live after it is important. You need to look at things like life insurance, medical costs, medical insurance costs, child support, changes in your circumstances. If you have a high conflict divorce, as I said at the very beginning of this webinar, the conflict is not likely to end when your divorce ends. So you're going to have these issues throughout. So you need to make sure that your other issues like custody and finances are well resolved, so that your life and the amount of contact you need to have with that ex-spouse will be minimized. There are a ton of different financial experts and advisors out there now. Some that are just certified divorce financial planners, or some financial coaches, other people that are experts in budgeting. I've found that there's been a great increase in the number of people that are providing divorce-related services. I think that's, believe it or not, unfortunately, because the divorce rate is so high that there's a need for a lot of additional ancillary services. So let's look at some ways that you can possibly minimize or limit your costs. Obviously, first is to represent yourself. Not necessarily the best choice, obviously, for many, many reasons. It is obviously going to be the least expensive. In a case like this, if you're both pro se, there's a good chance that you can negotiate and settle in a divorce case, in a normal divorce case. As I said, it works good for short-term marriages, no children, less assets, fewer issues. But high conflict cases, this can be actually a very powerful tool if you're able to manage it. Courts will often, judges, when I say courts, I mean judges, and when I say judges, I mean the court. So judges will often be quite lenient to an individual that is not represented, especially in a high conflict case or when there is another attorney on the other side or both. Although the law says that you are to be held to the same standard and to be expected to know the same information as a lawyer would, the reality is that they don't really hold you to that standard, and they can't. You couldn't be expected to have that knowledge. So you will get some leniency. Courts will bend over backwards to make sure you aren't punished for the fact or penalized because you don't have a lawyer. But keep in mind, there's only so far the court can go. So depending on your own capabilities and your own limitations as to whether or not that's a good option for you, but it is a good tactic to consider. Another one is mediation. The mediator is a general person or a neutral person who is paid hourly to help resolve it. You exchange financial information, and the purpose is to facilitate your discussion. Now, this is a great option for most cases that are not high conflict. You have to be very careful when you have a mediation in a high conflict case. You will often have people in high conflict cases or the person that is the aggressor wanting mediation, and everybody around you will say, oh, it's a great thing, go to mediation, and it helps you settle your cases. But when you're going to mediation because the person who's aggressive wants to use the mediation as a way to exert power when nobody can see you because it's a confidential closed proceeding, it's not the best choice for you. That I often tell people, and I often tell mediators, that a lot of times I don't recommend people go to mediation because I can tell that the whole reason that the other person or even my client is recommending it is if there's a desire to exert control, and it's just not going to help anybody. There is another option, a newer option called collaborative divorces. That is it's a new area. It's also becoming very popular, so it's a popular buzzword. This is where a lawyer will try to help people settle, just like a mediator will. The difference in a collaborative is the idea is to work together with more than just one person, or like you have one mediator sitting in the middle of you two. You will have usually a lawyer, but you should also have, well, two lawyers, three, I guess. One who's a collaborative mediator, facilitator, let's call him or her. Then the two lawyers that represent the parties unless they're going pro se. You will often also engage other experts at the onset to help facilitate all of the issues. So you might get one custody expert or a counselor or a financial expert in the very beginning, and all the parties are supposed to be working together with these experts to facilitate the outcome. The concept is a good one. Again, for people who are willing and desirous of actually using it to facilitate their issues. If they're using it to exert control because the process is not as supervised or as scrutinized, it's not going to help you. And another thing to look at that may not be obvious when you're reading or being discussed to go into collaborative law is the lawyers that are hired to engage in the collaborative law have to agree that if the case does not resolve by the collaboration, those lawyers cannot represent the parties in the future because they would have been privy to financial information, settlement discussions. The purpose of collaborative is to really work together. The intention is that everybody can be honest and put everything out on the table and work together. Again, it's a great process. It's not necessarily one that's going to work if you have a high conflict case. And sometimes you start in the collaborative and you find out you have a high conflict case, and that process is over. So that really leads you to litigation, which is where most high conflict cases will end up. I believe the statistics right now that of divorce cases, or as well as any divorce or any litigation, I think maybe 1% of all cases go fully litigated to a trial. And of that 1%, I think only 1% of the 1% actually complete the trial. And the reason is, first, it's the most costly aspect to a divorce. Usually there will be attorneys on both sides. Taking a trial on your own is very, very challenging and not something I ever recommend. You have court fees, you have filing fees, you have expert fees. It is astronomically expensive, even in a simple case, just the amount of time. And that is often a very powerful weapon for a high conflict individual, especially if they have, like I said earlier, access to the finances or greater financial freedom. They use the threat and the control of going into litigation as a way to exert control. So sometimes it's sort of like a game of chess where you need to keep moving and hope you're moving well to be victorious at the end, because it's not like poker where you can just bluff your way through something like this. So what can affect costs as you go through a high conflict divorce or custody case for that matter? Obviously, it's going to be yours and the other party's behaviors. The nature and complexity of your issues will have a part. I know I said before, divorces are complicated. People are. Certainly, there are complicated issues. Two people living in an apartment, W-2 wage earners for $30,000 with no children are a lot easier than people that own like a cash pizzeria and have 4 kids, 4 years old. Next is whether or not you're going to need experts to value businesses or earning capacities, assets. You don't ever need to have experts. I have a case now where they have millions of dollars and they really are stipulating to the value because they are that comfortable in their understanding of their situation and their assets, and they certainly don't want to spend all their money figuring it out. And the last is, and this is important, is the court scheduling and availability of people. Some of the biggest costs that you incur in a high conflict divorce is thinking that it's coming to an end because you're given a trial date, and then you come into trial and the court says that they're too busy, you have to sit out in the hallway and settle it, and they make you sit there all day, and then you come back another day for trial and they do the same thing. Or you start your trial and they take 2 hours of testimony and then they say come back next week. And the lawyers, if you have a lawyer, has to prepare every single time because 2 weeks passes and memories fade. Documents get reorganized or disorganized. So you need to look at this, and any attorney that has experience in litigation in high conflict divorce should be able to see early on in a case whether it's a high conflict case and what your scheduling issues will be, what your judges like, whether they do or do not give trial dates that they keep to, do they hear motions promptly. These are all things going into the cost that I told you need to plan from your very beginning. One thing people always ask me about is getting attorney's fees, and will they get attorney's fees? Now, I'll go through the factors in a second, but let's do that right now. Simply put, it's the needs of the person asking for it, the ability of the adversary to pay, and good faith in instituting or defending the action. That's what the court looks like in a nutshell. When it comes to contempt motions, which we talked about earlier, some people are just signing on now, the court rules actually require that a court issue or award attorney's fees. But to be honest with you, a good majority of the time, or not most of the time, they either do not issue any, or they'll issue some, but not nearly all of them. And my belief is that they do it because they don't want to encourage you to return. So if you had to file a motion for contempt because somebody didn't comply with something, court orders them to comply, but you spent legal fees to get the compliance, you're a little less likely to do it again because it cost you. And while I think that's horrible, I think that's what the courts do because it reduces litigation. So don't expect to get fees. I tell my clients all the time, don't expect to get fees because if you get them, you're just ahead of the game. So let's talk a little bit about, as we wind up, approaches and what you need to do when you are in a high conflict divorce. First, get support, whether it's in your church, a therapist, friends, family, professional or unprofessional. There are going to be, depending on the level of conflict and level of issues, you're going to need a lot of support. Work with a mediator, see if you can get a compromise solution to your divorce. As I said, I'm not usually very hopeful that they work, but you should consider it, even if you're losing in the circumstances, because, and I believe we'll touch on this a little bit coming up, sometimes it's better to cut your loss and just go. A lot of people have a hard time accepting that, and obviously it depends on the issue, but it's something you need to keep in mind. There's a lot of benefit to moving on quickly. which be willing to compromise and walk away. Compromise is usually considered a lose-lose. Sometimes you're losing a great deal, but you're gaining more than you realize because you get to move on with your life and you get out of this high conflict. It can be, in many cases, almost toxic. So let's look at also, before we wrap up, what to expect in your case, what you're going to have to do. I touched a little bit throughout the topics, but I like to give some bullet points here. First of all, I preach from the moment I open a case to the end, document everything. You can't be expected to remember everything, but notes are sometimes admissible in court. You are also allowed to use them to refresh your memory. Expect to be blamed. I said that in the beginning, especially when you talk about narcissism and BPDs. The stories and lies you will hear are sometimes so egregious that you need to be prepared in advance. Don't be the reasonable one. Now, this is something you will rarely hear from me. You will never hear it from a judge. Because most of us want you to be reasonable, but when you have a high conflict divorce or you have a narcissist or a BPD, being reasonable doesn't help you. It actually hurts you. It sort of puts fuel on the fire. My approach to being reasonable is give and get. If you're giving something, you're getting something in return. If they're asking you for something, you're asking for something in return, which is reasonable and accommodating, but it's also fair. If they're not willing to give you something, then you shouldn't be willing to give them. It also trains them that every time they want something, they're going to have to give something. And they may, to some extent, ask for fewer things because of it. Be assertive and defensive. It's a balance. You don't want to be too assertive. You don't want to be too defensive either. But you can't just say, well, it's not worth responding to, or, if I just let it go, it'll go away, because it won't. So you need to really be toe-to-toe in this kind of a conflict. Expect gross exaggerations. I keep saying it. Sometimes you'll hear things that are so egregious, they're unbelievable to you, but not to others. They are always false allegations. Law enforcement involvement. Depending on the nature of your cases, high conflicts don't always have law enforcement, but obviously many of them do. They're often used as a tactic. Often, things like a restraining order is used more as a weapon than a protection, which isn't what it's intended to be, the protection. But people know how they work, so they will often use them as a tactic to gain leverage in a divorce. High conflict cases, very, very common. A lot of times they'll use police officers to make reports of things that may not have even happened, or because they get to exaggerate them and put it into a writing. Now, these reports mean very little in court, but the litigants don't really realize that most of the time. So a lot of people are taken by the fact that, my ex made a report and told this to the police. Now, they don't mean anything, but they are a very common tactic, a very strong scare tactic. So what do you need to do to prepare? First of all, keep copies of everything. Documents, credit card bills, letters. If you can't get copies made, use your smartphone, take a photograph. A lot of people don't realize that they can do that with such ease. Or at least write down where you saw things from, the name of the account you saw in the tax return, the name of the credit card that came in the mail, so that you have that. Talk to friends and witnesses, not just for support, like I mentioned before, but because you may need them to be witnesses in the future, and you want to know in advance who's a friendly witness and who isn't. Some people that are your best friend all of a sudden don't want to get involved, and you need to know when these egregious custody allegations are made. You need to know who's going to be your friend in court and tell them that it's not the case. Seek therapy with some experience in BPDs, whether this is therapy for you or family counseling, or even your attorney, which I say here next. Make sure they have experience in high conflict divorces. They are very unique, and they aren't as common as most people think. Like I said in the very beginning, a lot of people think they have a high conflict, but it's not in actuality. Ask these professionals for predictable scenarios. What do they foresee happening? I tell countless people who come to sit with me, get a tape recorder because you have a domestic violence case coming up soon. That I just know at some point in time they're going to get in a fight, and that one person's going to call the police and allege there's domestic violence. And without a recording, it's your word against theirs. Shut down internet working pages, or at least stop posting on them. They are admissible. People don't realize that other people are looking at them. It's not helpful. I tell people, don't put anything in writing. Don't leave any voicemails. Don't send any emails that you don't want a judge to read. And a lot of people in a high conflict lose that point because they get wrapped up in the emotions of it. So what are some tips? First of all, minimize contact. don't have to respond to every email that they send. You don't have to be on time for every parenting time exchange. Plan for the worst, because even if you are on time for every parenting time exchange or you answer every email, it's not going to help. It's not going to change. A person that's dead set on high conflict or has a BPD issue, nothing you do will or won't change that. Document everything. It's the thing I say the most often. Respond to every frivolous allegation with accurate, non-defensive statements. I said a moment ago, be assertive and defensive. Don't assume by letting something go that it will go away. Not only will it not, but they will probably bring that up and harp on that over and over again, and then it's hard to come back and explain why it wasn't addressed in the first place. Don't fight their battle, but don't let it go away unaddressed. Never admit a mistake. Some people think that, taking the high road and exposing themselves and admitting something bad will make them look good. Yes, that's somewhat the case in most divorces. It's not here. If you made a mistake, figure a way to fix it, but don't say, yes, I made a mistake, because they will zone in and destroy you. Another thing that's very important, have an emergency plan. Not that I don't like to scare people, but you never know how high conflict will go. So know where to go. Most towns will have safe houses, domestic violence shelters that are private, that you can't just type in the internet where to go, but the police can direct you, lawyers can often direct you. Copy the records, like I said a moment ago. Photograph them if you have to, write down where they're coming from, document everything. Choose every word carefully, whether it's in an email or a voicemail or even a motion. A lot of times lawyers will write the motions and the clients just read it because they think it says what they need to. It's their lawyer that wrote it. But you have to make sure that it's right, because if you put in something that's a mistake or inaccurate, again, they will zone in on it. And like I said before, expect that a judge will see all of your communications. It's damaging because high conflict, sometimes you lose control, you get angry, it happens, we're human, but you don't want to do that. You don't want to lose control, and you don't want to do or say anything that's going to make you look really bad in front of a judge. Another thing you don't want to do when it comes to your children, don't ask them questions about the other parent when they're on or away with them. Don't discuss the court or motions with them. I even say keep your papers away, stay off the phone when you're around them, because kids hear and pick up a lot of things, so they understand. And like I said before, try to get them into some kind of therapy, whether it's family therapy or in school. There's a lot of resources available now. Attorneys, other therapists in local areas can always give you resources for high conflict. Real quick, I know we're going a little over, a lot of information. So dealing with your costs of litigation. First of all, how you deal with your litigation, you have to continue the rhetoric. You will have to point out from the very beginning and each time you're in court the nature of this person's conduct. I usually start out, if I know I got a high conflict case, I will usually start out by saying, Judge, you will see it, in this motion, they make these allegations are unsubstantiated. And I will tell the judge that every time going forward, you will see these things resurface because this is their rhetoric. You will see that they will bring this up again and again and again. So when I do go back into court and it is brought up again, I can say, see, Judge, I told you the first time, or here's my motion where I pointed out that this is what they were going to do every single time. Because the first impression you make is going to be the most important one. It's just like when you meet people. So if you're walking into court against some egregious, outlandish, you have to say that, Judge, it's outlandish, and this is what you're going to see every single time that we come. If you can, you want to strike first. If you know there's going to be a custody challenge or an allegation of fitness, bring it first. File a motion for custody. File a motion to get an expert appointed. File for family therapy. Don't be on the defensive if you don't need to be. And I don't say this because I'm a lawyer, put money aside for your divorce fund. Whether or not it's for a lawyer, whether or not it's for experts or therapists or support. Make sure that you have it before the high conflict starts, because again, they often have greater control over the finances and use the finances for control. So you need to be prepared for those times where you won't be able to access the funds that you need to. Real quickly, what do you do to approach custody issues to minimize a conflict, which generally is not necessarily possible? I tell people again, and this is uncommon advice, do not try to co-parent. It doesn't work. give and get. If they're asking for a change of parenting time, then you're asking for something else. If they can't make a visitation or a parenting time exchange, then you ask for a change in yours later. Don't think that by giving into them that it's going to make your co-parenting easier. It will not. Again, therapy. Always have therapists for you, for your children, whether it's court appointed or family or just something for your own. Watch for parental alienation. I actually did a webinar not too long ago on this. This is another buzzword people use. Most cases don't rise to the level of parental alienation syndrome, but there is alienation attempts you will see early on. And if you don't address them early on, they are often effective. Don't feel guilty. Don't feel that you're unfit. Don't let their rhetoric convince you that maybe they're right, or maybe it's just better for the children that you back off and it will subside, because it doesn't. One thing I keep stressing here is don't expect it to be handled like most people in most cases where don't expect it to be reasonable, and don't expect the passivity to actually help you. Now, in closing, here's some contact information. Like I said, a lot of the information that I give here is contrary to what most people will give you. It's also contrary to a lot of advice I give. But when it comes to a high conflict case, these are the points and the issues that you're going to need to know. So let's just take a second. I'm just going to wrap up here on my recording end and see if we have any questions. Just give me a second. I got to open up my panel here. Feel free, if you didn't take a moment to type in some questions, Dorian, to type them in now. I'm having trouble opening my panel, so bear with me here. All right, here we go. All right, so I don't see any questions. I'm going to hang out for a few minutes in case there are any. Just type in. There is a panel on your right side. It says your questions. You may have to hit the tab down to open it up and then type it in there. So, okay, we have a question posted. And I believe also, and I apologize for not being certain, but I believe that nobody else sees your questions or even your name when you post it. So don't worry about that. Have you ever had cases where one person has Asperger's? Not that I've been certain of. I've had cases where they believe, but Asperger's is a newer issue. So a lot of the adults that may have had it weren't really diagnosed with it. What I do find is in cases of any kind of autism, Asperger's, BPDs, anything where there are sort of newer issues, newer realizations that adults and adversaries, lawyers, it wasn't recognized. So a lot of people tend to self-medicate because what they were dealing with was undiagnosed. So that in and of itself creates a new issue that sometimes you have a lot of drug addiction or alcohol abuse. For people that may have had Asperger's or autism or ADD and were never diagnosed, that can in fact lead them to be the people that fit into the category of high conflict, just because they're unaware of it. Another person asked if there will be a slideshow sent to you of the webinar. I do plan to do that. I normally email the registrants a copy of the audio. I've been having some problems with YouTube. So you can email me if you want to get, if you're certain that you want to get a copy of the webinar, but I usually do my best to get it posted and emailed to everybody that attended. The person who posted the question about Asperger said they're great at fooling others. Well, and that's unfortunately the case with most BBDs. Sometimes they're even good at fooling themselves. The problem that I see is that people aren't ready for it. See, the thing that most people don't understand is we go into, you and I go into a divorce court thinking that the judge expects everybody to be lying, but it's just the opposite. They either believe or act as if everybody's telling the truth. So when somebody walks in and says, my wife is a drug addict, child abuser, they turn to the wife and say, how long have you been using drugs? Instead of saying, well, what proof do you have? Why would you say that? Why would you co-parent for 10 years? They put the other person under a spotlight, on trial almost, for something that's completely untrue and unreasonable. And now you're battling to defend yourself it's a horrible situation. That's why the key from this always is be prepared going into it. All right, next question. I'm just going to read through it because it's a long one. So I will need a contempt motion. My ex has not filed anything in our divorce judgment. I've found out there are mortgages in my names. He was a mortgage broker, filed tax returns in my name with his accountant, provided bogus returns. Actually, I'm not going to read all of it. I'm going to read through it myself because unfortunately, these are like fact patterns that are very common to me. So it's kind of easy to identify. I'm not sure what your question is. Oh, here it is. My question is, okay, what information should I concentrate on bringing with me to my consultation? Well, I don't know if you mean with me or in general. I can tell you with me, what I do is I send out a questionnaire before you come into a consultation with me and ask you what your issues are, who's involved, what you need to discuss. When I review that before you get in, and then I will send you an email of documents I need. So like, for instance, in the story that you're setting forth here, I would, going on the assumption you may have been divorced, I would ask you to see either your divorce judgment or your settlement agreement. I'd ask to see the tax returns, your case information statements, and anything that you have that documents these issues long before I meet with you, so I can take the time to go through it and know exactly what we're talking about, where we're come in. So I guess that would be my answer to any consultation you sit with anybody. In my experience, most lawyers don't prepare beforehand. You go there and you tell your story, and then they tell you, well, if you hire me, we'll need these documents. I don't like that because I don't think I can advise a person unless I really understand their case before I meet with them. Okay, so hopefully that answers your question. If it doesn't, or you have another, just post another question up. Moving along. Okay, I was about to read a question and I was told not to. It didn't print correctly. So, like I said, I got all the time in the world. If there are other questions, I'll give it another minute or two because I don't see any others being posted. Not going once. All right, well then I thank you for coming. I appreciate your questions and assistance. I will do my best to get copies out to you and up to my YouTube page, and hopefully we'll see you next month. Have a good night.